Welcome everyone. We're pleased that you've joined us for today's webinar titled Case Reveals Flaw in Beneficiary Designation Shortcut. Webinar will last approximately 15 minutes, and at the end you'll be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. My name is Linas Sudzius, and I'll be your presenter today, so let's get started. So we're going to talk today about how a court case revealed a flaw in a beneficiary designation shortcut. What's the shortcut that we're going to be talking about today? Well, it comes from a fairly common situation, at least in my experience, that financial professionals run into. Let's say you've got a married couple who have one or more little kids. You sell them life insurance or an annuity or another financial product for which they can name a beneficiary. Now, choosing the primary beneficiary in that situation is normally pretty easy. It's usually the surviving spouse. But the contingent beneficiary designation is a little trickier. The temptation or the first go-around is probably to name the little kid or little kids directly. That choice is flawed because if a minor ends up being in line for money, somebody's got to go to court to get permission from the court to act on the minor's behalf, and that process isn't particularly straightforward or simple. And the process, even after a guardian or a custodian has been named, is a little bit labor intensive because the court wants to have a say in how the money is used and how it's invested. So in a lot of cases, we'll recommend that parents create a trust for the benefit of their minor child or children. But that's, in a lot of cases, that's not really a practical approach, because if you've got to send your clients to their lawyer and have the lawyer do work before you can sell life insurance, for example, even a term insurance policy, it's going to frustrate a lot of the sales that you want to make. So the clients, in a lot of cases, are going to suggest naming a family member, a trusted family member. Let's say it's the wife's sister, as the beneficiary, because the wife trusts her sister to use the money for the benefit of the minor kids. And that's really the court case that we're talking about today. The court case follows those facts pretty closely, and the court decision kind of reveals the flaw in that approach to beneficiary designation. So without further ado, let's talk a little bit about the case. The case is Lane versus Corto. They tried to take a shortcut which ended up causing more damage than some of the other beneficiary choices they could have made. And it's a case of Teresa and Charles Lane, who were married. They had a son, Connor, who was born in 1997. Now, Connor is probably of age at this point, but at the time the court proceedings were taking place, he was a minor. Mrs. Lane owned an insurance policy on her life with a death benefit of $600,000, and her husband was the designated beneficiary of that policy. So when Connor was 12 years old, Mrs. Lane, the insured, was diagnosed with terminal cancer. And so a few weeks before she died, Mrs. Lane added her sister, Amanda Corto, as co-beneficiary with her husband on the life policy. So Amanda and Mr. Lane, the spouse, were equal beneficiaries, and each were to receive at Mrs. Lane's death $300,000, half of the insurance proceeds. Then what happened is Mr. Lane was also diagnosed with terminal cancer, and he was not, in fact, expected to outlive his wife. But he did outlive his wife. In November of 2013, Mrs. Lane passed away before Mr. Lane. And Mr. Lane had not been aware of the beneficiary change his wife made before her death. He didn't find out about it until he tried to collect the $600,000 death benefit. Found out that his sister-in-law was beneficiary of half the proceeds. And Mr. Lane believed that his wife left half of the proceeds to her sister so that her sister would in fact use the funds to care for Connor, who was 16 at that time, and on the verge of having no living parents because, as you may remember, Mr. Lane was also in a situation where he was terminally ill with cancer. So what did Mr. Lane do? Because he was concerned that his sister-in-law wasn't going to use the money for Connor's benefit, he filed a court case against his sister-in-law and the company that issued the life insurance policy. And the case went to trial. Unfortunately, the trial occurred more than a year after Mr. Lane's death. And there was some testimony at the trial that revealed that Connor was Mrs. Lane's top priority and that she wanted to make sure that Connor was going to be taken care of in the event something happened to her. And so Mrs. Lane and her sister had been close their entire lives. That's what the court testimony showed. They'd promised to take care of each other's children if it was needed. And the testimony showed that Mrs. Lane had informed her sister that there would be money available to take care of Connor. Now, Mrs. Cordo testified that she didn't know that she was a beneficiary of the life insurance policy. And she and her sister, Mrs. Lane, the insured, never had any discussions about what the money from the insurance policy should be used for. And so the trial court, after hearing all of the facts, decided that the $300,000 that was earmarked for Mrs. Cordo, the sister, should be restricted, and they should be awarded to Connor on the theory of promissory estoppel. That is, Mrs. Cordo had promised her sister that she would take care of Connor. Mrs. Lane, the insured, earmarked $300,000 of death proceeds to Mrs. Cordo for the purpose of taking care of Connor. And so because the parties had a meeting of the minds, at least when they had this conversation, the trial court decided that the $300,000 should really be used for Connor's benefit. Now, Mrs. Cordo didn't like that result, and so she appealed the decision to the Tennessee Court of Appeals. And the Tennessee Court of Appeals, in making its decision, looked at a history of similar cases, and Connor's attorney said that because of the prior cases, the Court of Appeals should affirm the decision of the trial court that Connor should get the death proceeds. The appellate court said that there was, in fact, precedent that a beneficiary designation could be overridden, but it could only be overridden in cases where there was a clear contract, such as a divorce decree, that required it to be overridden. And because the circumstances weren't so clear here in the Lane versus Cordo case, the appellate court reversed the decision of the trial court and said that there was insufficient reason to override the plain language of the beneficiary designation. And so the bottom line was that Mrs. Cordo would get the death proceeds and would have no obligation to use those death proceeds for Connor's benefit. And so what are the lessons from the Lane versus Cordo case? Well, first of all, if we assumed that Mrs. Lane did intend for the funds to be used for Connor's benefit, Connor lost out on $300,000. Now, assuming his dad left him the $300,000 that Dad inherited or Dad was beneficiary of, that money was still retained, but Connor lost out on the funds that was left to his aunt on his behalf, and he also lost out on whatever it cost him to pursue the court case. You know, in a perfect world, as I mentioned on the front end, the Lanes would have set up a trust for Connor's benefit, and that trust would have been the beneficiary of the life insurance proceeds, instead of Mrs. Lane simply trusting her sister to do the right thing with the money. And Mrs. Lane may have thought that she didn't have enough time to go to a lawyer and create a trust with her death being imminent. So instead of naming her sister as the direct beneficiary, what could she have done in the alternative? Well, one of the things that she could have done was to use the UGMA or UTMA rules. In Illinois, it's UTMA, the UTMA rules to her advantage. Because it can take a long time to create a trust, you can use a custodial account. UTMA is a custodial account as a quick and easy way to have funds directed for the benefit of a minor, but still have an adult be able to exercise control over those funds. And she could have named her sister as an UTMA custodian for the benefit of Connor, and then it would have been clear that while her sister would have collected the death proceeds, she would have been required to use those proceeds for Connor's benefit. And if she failed to do so, Connor could have sued her for misappropriating the funds, for stealing the funds if she didn't use the funds for his benefit. So, and then, you know, what does UTMA require? Well, it requires that the custodian act on the minor's behalf. There's a lot of flexibility for how the custodian will use the funds on the minor's behalf. What's the downside of using UTMA? Well, once the minor comes of age, depends on the state you're in, but that might be 18 or 21, depending on the state you're in. The only thing that the custodian can do at that point is turn the money over to the minor who has become a major, right, who has become an adult. And so that's the reason to choose, one of the reasons to choose a trust rather than a custodial account. With a trust, you can have restrictions for much longer. Just because somebody becomes 18 or 21 doesn't mean they're going to be good with money. A trust can last much longer, but it's harder to create a trust. You got to go see a lawyer to do one right. And so, you know, if you've got to do something in an emergency, UTMA isn't necessarily a bad alternative. So what are the other things, what are the other lessons to consider from the Lane Cordo case? Well, you know, I think there are certain things that we should consider. First of all, when deciding on beneficiary designations, we should never assume that deaths are going to occur in a particular order. In this case, the wife died before the husband. That was a surprise. And the wife's sister ended up being in line for the proceeds. Now, if the deaths had occurred in a different order, it would not necessarily have been any better in this case. But it's a reminder, this case is a reminder that, you know, deaths don't always occur in the order that we expect. The second thing is in this case, Mrs. Lane made the beneficiary change, it seems like, from the facts of the case on her own. She didn't get the agent's input. So as we work with our clients on selling them life insurance and financial and doing other things on their behalf from a financial perspective, we should encourage them to contact us. Let us be part of the process when they make beneficiary designations. Discuss with clients the dangers of assuming family members are going to do the right thing with monies that are earmarked for specific purposes. Encourage them to dot the I's, cross the T's with regard to legal requirements and show them this case, right? If they balk at doing things the right way and insist that family members are going to do the right thing, I think all you can do is show them the reality. This case is a real case, and it's a circumstance where things didn't turn out the way that that mom and dad, they probably didn't turn out in the way that mom and dad intended. And so going through the legal process is kind of the back end of the belt and suspenders approach to make sure the right thing gets done. And then finally, you want to stay in touch with your clients. This case is a reminder that staying in touch with clients and helping them through processes when family things are going on is really good. In this case, if their life insurance agent knew that both the Lanes were in terminal cancer conditions, perhaps the agent would have taken a little bit more care to help think through beneficiary designations and the consequences of making one change or another, and may have had the opportunity to be more proactive with regard to this case, and perhaps this court case could have been avoided. So that wraps up our webinar for today. Let me close by saying this. I'd like to thank you for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com, asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Feel welcome to join us for the next monthly webinar held on the first Wednesday of next month, August 2nd, at the same time. Next month's webinar will be titled Government Protection of Older Clients. You can find an archive of past webinars on our YouTube channel, and today's presentation will also be posted on our YouTube channel by the end of this week. And finally, for more information about the services that Advanced Underwriting Consultants offers, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again, and best wishes for continued success.